Yes. Why? What is it? Oh, okay. Yeah, eyewitnesses to the thing.
Eyewitnesses or there are 10 witnesses also.
How does it matter? I don't know. Depend.
They I think that little bit confused, but you will take up it in the month of January.
We can take it up in December also.
Year ending not.
Huh?
Let it be in the last week of January.
Why last week? Why?
January
Hey,
lots of,
22 matter. This is a 22 matter.
yes. Your Lordship may
These are all 23. These are all no.
Your Lordship may suggest a timely as per your Lordship's convenience in the month of January. Yes, no problem.
Okay, atas training.
Six January.
Yes.
Right, on the prayer for adjournment made by Mr. B.D. Kawar, learned senior counsel. It is not objected to by the learned APP. This is the matter on.
Discuss.
6th of Jan.
The matter pertains to conviction under section 302 IPC, where there appears to be witnesses, eyewitnesses.
We are blessed.
My pleasure. So I beg to mention from this thing, I got 10, 11, not issue. Takes to any day.
Next week we'll be having a lot of DB1 matters.
Any convenience, sir.
After that,
Then with the what high for us.
May please, your Lordship. Lordship, with the consent of the other side, I beg to mention item number 2 of today's list. Lordship, 2 weeks' time may be granted for filing the affidavit in opposition. Lordship.
you're for whom?
I am for the respondents. For respondent numbers 227, Lordship. 227 and
You're for the state.
Lordship.
But what? You did not file affidavit.
No, Lordship, that is yet to be filed.
What? You're for the appellant.
I'm for.
What right of yours has been violated?
In fact,
It is regarding setting up of town committee.
I know the number of town committee.
Lordship.
Yeah, the town committee area has been made in terms of the act.
Lordship.
Now,
providing all the facilities.
you already have it.
And
So what is wrong if it is looked after by them, by that number of town committee? What what right of yours is violated?
then our fund has played for.
You have already utilized. Good,
Yeah.
you have utilized. So they're not going to break it down. How does it affect you?
Yeah.
No, you have got to you have got to give your side of the story.
Yes.
What right of yours is affected?
We're collecting tax.
I said they'll be collecting tax. Now they're not collecting tax.
Now, as of now, that has been stayed.
No. So if it is not within the town committee area,
Yes.
then there's no taxes collected.
Not tax.
Okay, so tax is the issue.
Yes.
Okay, right. Miss
M. Devi, Lordship.
M. Devi,
Lordship.
appearing for the state government,
For respondent numbers 227 and 9 also.
point 27 and 9.
Lordship.
Praise for how much time?
2 weeks' time, Lordship.
Praise for 2 weeks' time to file affidavit. Praise allowed, list the matter after vacation.
Also, there is an interim order.
Interim order to continue till the next day.
Obliged, sir.
May I please your Lordship?
This,
Lordship, I'm mentioning for listing of a criminal appeal in the month of December, any day,
give a date.
16th. Oblige, Your Honor.
May it please, my lord, appeal against conviction, my lord. The appellants were my lord, convicted by life, my lord. And in the meantime,
So-
the
Yes,
appellant number was died, my lord.
April number 1 died.
One died. And my lord, record already received, my lord, and paper book also
So
received, my lord.
this appeal is by 2 persons.
By 2 persons, one died,
One died.
my lord. So, my
So
lord,
who has died?
Applicant number Shyama Prasad Goswami, my lord.
Yes, when did he die?
In the month of February. In the month of February of this.
Any death certificate?
Right now, that is not in a position, but we may collect it.
So we can still hear the matter
Lordship, my lord,
for final hearing.
Lordship, my lord.
Paper book has been given.
Prepared, Lord. The order was, earlier order was in that regards only, Lord. The
Huh?
Earlier,
Yes,
earlier.
it is prepared.
Mm.
Okay, right. Heard Mr.
K. Barua, my
K. Barwa, learned counsel for the appellant. Comma, and Miss A. Begum, learned APP. Mr. K. Barwa submits that the appellant number one, Shyama P.D. Goswami, expired on
In the month of February 25.
February 2025. He submits that he will produce the death certificate or what? Produce the death certificate on the next date.
Lordship.
Copy of the death certificate on the next date. He also submits that he has been given a copy of the paper book. Pustak.
Lordship.
In view of the appellant being given a copy of the paper book, in view of the appellant and Miss A. Begum having been given copies of the paper book, list the matter for hearing. When? What is this matter about basically?
So, my lord, convicted under section 302, my lord.
302, na? So,
Let, my lord, I may be kept pending, my lord.
why?
Eyewitnesses are there, Lordship.
That's what eyewitnesses are there. So we will dispose of the IA. I think who is the wife is the eyewitness,
The wife, Lordship, and daughter-in-law, son,
daughter-in-law, son.
Son. Son is injured. Eyewitness come injured witness.
And then this is the matter for hearing when?
After 1 or 2 months, my lord.
No, no. You give it in second week of December. Right. In the IA, right. Heard Mr. K. Barwa, learned counsel for the applicant, as well as Ms. A. Begum, learned APP for the state. This is an application under section 389 CRPC for suspending the sentence imposed upon the applicants on their conviction under section 302 IPC. Pursuant to the judgment dated 19/12/2023 passed by the Additional Sessions Judge Dibrugarh in Sessions Case number 149/2018. We have heard the learned counsels for the party. On a perusal of the evidence of the prosecution witnesses, the eyewitnesses who are the wife
And son, my lord.
and son
Son.
of the deceased have apparently seen the appellant
PW1, Lordship, he is the injured and son.
assault the deceased with weapons. The son who is PW1
And
is also an
PW2
injured eyewitness.
daughter-in-law.
Huh?
PW2 is a daughter-in-law.
PW2 is also the daughter-in-law who had also seen the incident. On considering the above facts, we are not inclined to suspend the sentence imposed upon the appellant. Further, the paper book having been furnished to the parties and the matter being listed for final hearing on 16/12/2025. The prayer for bail is rejected. Next paragraph. The above being said, Mr. K. Barwa, the learned counsel for the applicant, submits that the appellant number one, Shyam Prasad Goswami, had expired in the month of February 2025. I is accordingly rejected and disposed of. No?
Like,
Just write one more thing. Any observation or finding made in this order shall not be constituted to be the final observation or finding made by this court at the time of final hearing of the appeal. Yes. Yes.
Sorry. Lordship, a medical report was called for we have already submitted on the last occasion. As regards his eye surgery, Lordship, a report dated 17/11/2025. Today, the matter is in fix for consideration. Maybe, Lord, I have not gone through the records, my lord.
Anyway, I think we should have a final hearing on
Yes, my lord.
because, yes,
Lordship, if my senior sister record now,
huh?
my senior is not available in Guwahati, Lordship, today. Any date may be fixed.
We are fixing the matter for hearing,
Final hearing.
final hearing. Right. No one appears. No, a genuine prayer has been made on behalf of Mr. H.R.A. Chowdhury, the learned senior counsel for the applicant appellant, on the ground that he is not available in court. Ms. B. Buyan, the additional PP present in the puस्तक. On considering the fact that the paper book has been furnished to the parties, comma, we are of the view that the matter is to be disposed of.
Medical report last time.
As such, this is the matter for final hearing. Next week, any day. Thursday. Yes, right.
Coming
Next
Thursday,
para.
date to ki ho?
Yes, right.
4th of
The
December.
matter pertains to the conviction of the appellant, who is apparently 76 years of age. Yes,
My lord, I'm praying for listing of a repetition, my lord, in the first week of December.
single bench.
Single bench two matter, my lord.
Huh?
Bench two matter, single bench.
Okay.
Deeply.
May it please the Lordship. The victim mentioned item number 12 and 13. I'm making this prayer of adjournment on behalf of Mr. P.K. Goswami. His wife has some medical issues for which he could not come to Guwahati today. Prayer is to have the matter on 4th, Lordship. Adjournment slip was also circulated and I think
Thursday.
Thursday, that's 4th of December.
He told me.
We cannot.
Lordship.
For the simple reason that next week, I'll be taking up DB1 matter, including the special bench matter.
Lordship will not have a single bench.
DB1 chief is not be here. And this case is really a problem, Mr. Das Gupta.
Yes.
I should release it. Let it be decided by the.
I have argued our case.
He says that he's not finished, that he'll take another day.
Right.
I cannot, this matter has been pending. I mean, you all are not finishing.
Substantially, I think it has been heard. Substantially, it has been heard. Lordship.
It's a different thing.
has been completed.
They are not concluding their arguments. I cannot hear, and it's been stretching over a few months.
I have
But then I think it will be over this time.
No, it's not being over.
No, it will be over.
No.
What the senior counsel has told to us is like this time it will be over. One date it can be over, Your Lordship. Lordship will give a date as per Lordship's own convenience. Then, if this gets not there.
Really, now, you see, I've never heard a matter for so long.
Yes. That is
That is true.
Actually, I have completed my argument.
You have also not completed. He will finish, then again you will want to counter it, I know.
No. We have given our written argument also.
They have already given. And still they're not finishing.
No, Lordship will cut short the hearing this time. When they appear, Lordship will give a deadline and cut short the hearing.
Food is also gone. I've forgotten the head of the argument. Where is the tail of the argument now? I've forgotten the head part. I mean, everything is now Greek to me. And next week, though, there's no chance.
Then, thereafter,
No,
next week.
so many matters. We'll have a new year.
New Year. A date in December, Lordship, your Lordship's convenience.
No. Too many. I think in fact I want to release it from Partha.
But Lordship will not when I'm appearing, when the senior counsel will appear, Lordship may take a call on that, but not today, Lordship.
We have adjourned for number of times. I mean,
Number of times, that's true.
I've totally lost count
That's true.
of the.
But then this
This
time he has some medical
No,
difficulty, so
This is all right.
yes, but
You can start your arguments afresh before a new bench.
yes. Lordship will kindly give a date, and on that date, Lordship will take a call when he is there, when the senior counsel is there. Lordship may take a call. I'm not saying anything today, but not when I'm appearing now, Lordship. Because Lordship has heard the matter substantially till now.
I heard the matter
that is-
substantially. I don't have a
Also-
photographic memory. I don't keep track.
Any date to your Lordship's convenience.
Huh? Okay.
2025, Lordship, not 26.
No. I'm not going to. Then we are going to have the ending of the year rush again.
The second week or third week of December, or the second week of December, any hearing date.
On the prayer made for adjournment on behalf of Mr. P.K. Goswami, Learned Senior Counsel for Oil India Limited,
Yes, your Lordship.
list the matter on twentieth January.
20th January. So the interim order may continue.
Interim order continuing.
Obliged.
My lord, I am praying for adjournment, my lord, item number 2. My lord, I have some personal difficulty today, my lord.
Why?
My son is insisting me to accompany him, my lord, in the annual day, my lord. He is participating in the drama.
Who's
That is,
the side?
my friend is there.
Sport department. I have prepared the case.
What is the issue here?
My lord, he was regularized. My lord, initially he was appointed as a master lawyer. Thereafter, my lord, after a selection process, he was regularized. After well, few days, my lord, they have kept in advice that regularization order. Like that, he used to work. He was getting the master wages. In the meantime, he retired. After his retirement, they have cancelled the regularization order. That is the issue.
Anyway, he says,
My lord has already decided. I have.
This is a different issue, my lord. In those cases, my lord, though, there is no regularization. In this case, my lord, he has
says that he has got some son to take to somewhere. Where?
school, my lord, annual day, Don Bosco, my lord.
Today?
Yes, my lord.
What time? They must have finished already program.
No, my lord. Okay, started.
Okay, right. On the prayer made by Mr. I. Sakia, Learned Counsel for the petitioner, who submits that he needs to take his son to the annual school day. List the matter after a week.
My lord.
As per my lord convenience,
Wednesday, matter, it may be, it's the bit anywhere, because,
List the matter after a week.
my lord.
in January lordship, and he will again take adjournment.
I'll take
January.
it. Then today, my
Next
lord,
week we'll put it, fix a date.
my lord. Lordship may observe that no adjournment will can put. My,
No, Mr. I. Sakia submits that he will not ask for adjournment on the next date.
my lord.
Obliged.
Obliged. With the consent from the other side, I beg to mention item number 1, lordship of today's daily list. Matter will be adjourned for the day and fixed on 2nd of December, lordship.
Lordship, I appear on behalf of the private respondent number 6, your Lordship.
Any objection
No objection, your Lordship.
on the prayer made by Miss
K. Bharan.
K. Bharali, Learned Counsel for the petitioner, to have the matter listed on 2nd
2nd of December.
2nd December, which is not objected to by the counsel for the respondent number 6. List the matter on 2nd.
Lordship, interim order passed.
Interim order to continue till the next day.
Much obliged.
Lordship, with regards to item number 4 and 6 of the daily list, your Lordship. Lordship, I am for the petitioner in this matter, your Lordship.
Lordship, the respondents have filed an affidavit in opposition on the 20th, Your Lordship. Lordship, we'd like to file a reply to the affidavit in opposition. It was short accommodation, Your Lordship.
Hmm. What has happened to the proceedings?
Lordship, the inquiry proceedings have been concluded against the,
Concluded?
yes,
Uh,
it was,
Concluded.
the petitioner had preferred a representation. The representation was,
Show cause notice was issued to him, no? Show
Yes.
cause notice was issued to him.
yes,
Then he has replied to that,
yes,
and that has been finished,
yes,
disposed of.
yes,
So he has got to put a challenge to that if he's agreed.
yes.
Then what remains?
Lordship, however, what had happened is that the entire proceeding was pending for 9 months when we filed this writ petition, Your Lordship, and the series thereof. Lordship, what had happened, culminating to that, they did not file the opposition for a long time. They only filed it on the 20th, Your Lordship. However, have not gotten a chance to go through that.
Oh, Mr. Counsel,
Lordship.
let us see, we'll see together. Where is the culmination? Where is the order?
Lordship, that is annexed to the affidavit. Lordship.
4 to 6.
4 and 5.
WPC
4, 5 and
445 today have filed.
This has been listed on your request today,
Lordship.
Yes, where is the order?
Lordship, on the last page, that would be,
Page.
That is the
on page number
in your affidavit. will
yes,
be-
Lordship,
Whereas the representation subject to
63 to 65, Lordship.
Okay, right. Last chance. Mr.
T. Kashyap, Your Lordship.
Kashyap, then counsel for the petitioner,
Petitioner.
submits that he needs how much time?
Lordship, 2 weeks.
He needs 2 weeks time to file the affidavit in reply. This other matter after 2 weeks.
Much observed.
Right, Lordship.
I please, Your Lordship, I beg to mention item number 10, Your Lordship. Your Lordship, I'm appearing on behalf of BK Sen, Your Lordship. Your Lordship, may kindly adjourn the matter for today, Your Lordship.
No. You cannot,
Your Lordship, there, A. Paul also, Your Lordship. We are newly engaged counsel in this case, Your Lordship.
no. You call your senior. These are two different classes of persons,
Lordship.
correct? One you want them to be regularized, absorbed, while the rules does not allow for the same. And the other is to grant relaxation of the qualification. How can you do that? 10 and 11, 10, yes, 10. How can you do that? There's no case. You call a senior. I'm hearing this. Yes.
They are covered judgment also.
Huh?
They are covered judgment also from the coordinate banks.
You cannot adjourn everything. Yeah. What is this? Yes. You call a senior. What is your name? I'll just recording your name.
Shaheen.
Huh?
F. Shaheen.
F. Shaheen
Your Lordship.
appears for the petitioner. Huh? On behalf of
BK Sen.
Mr. B.K. Sen, learned counsel for the
Petitioner.
B.K. Sen. Item 10.
Yes, Your Lordship.
His name is not here.
His name is not reflected in the cause list.
Or
Your Lordship.
B.K. Sen. Huh? You call him.
Okay, Your Lordship.
This one,
Will be taken up. We were disposing of the matter.
matter is listed by order, my lord.
Huh?
This matter is listed by order, my lord.
By order, whose order? Let me see whose order, by whose order.
On last occasion also, this matter was
Mentioned by whom? Mentioned by whom?
Lordship, as per the instruction I mentioned.
It cannot be, so you have listed it as per instruction of B.K. Sen.
Yes, Your Lordship.
Tell him. The judge court is not allowing adjournment. If he doesn't come, we'll disposing of in his absence.
May it please the Lordship. Lordship, I'd like to mention item number 3 for adjournment. Lordship, the senior counsel in this matter is on leave.
Who's the counsel?
Yes, KK Mahanta, Lordship.
When do you want?
After a week, Lordship.
Madam, you're for the other side?
No, I'm for the.
Okay, right. Adjournment prayer has been made on behalf of Mr. K.K. Mahanta, senior counsel, who is on leave. List the matter after
A week.
a week.
Much obliged.
May I please, Your Lordship? I beg to mention item number 9.
9.
Yes, we would like to file an affidavit in reply, so we need some time for.
Give me item 9. Where is your senior, madam?
She's in another court.
In another court. Okay, very good. I think she should come. No? What do you think?
She's having another matter in another court.
You will wait for her. Let her finish. Let her come. She has got some explaining to do.
It's available for admission.
My lord, item 7, my lord.
Ah.
My apologies, my lord. I'm not physically available. I'm slightly under the weather. I appear for the petitioner, my lord.
Yes.
Yes, my lord. In this matter, my lord, it relates to the petitioner who's actually leave applications for 2 years. I mean, they are divided into 2 phases, my lord. One starts from 2005 to 2009, where the period of applications are actually on record. And the other period of application is from 2009 to 2013, my lord. For the period of 2005 to 9, we have filed the leave applications. They are on record, which relates to my illness, which includes tuberculosis and other various reasons. And those applications were filed. Subsequently, my lord, when I went back to join in 2013, after being declared fit, I was not given the charges, and therefore I could not join as a lecturer diet in Dibrugarh. Subsequently, my lord, I filed a representation to say that yes, from 2005 to 9, I had filed my application, but from 9 to 13, my applications could not be filed. The reasons were quite eminent, and I have said it in my application. Therefore, kindly consider my leave and let me join. The order was subsequently filed, my lord. That order is extremely important, my lord. Kindly come to page 92 of my writ petition, my lord. That is my representation that I filed when I went to join in 2013. That is 13th of August after being declared fit. This application, my lord, the relevant part is at page 93, my lord. At para 9, I'll read para 7, my lord, first. After my recovery of illness, I joined my services on 13th of August 2013 and submitted my joining report before the District Elementary Education Officer, Tinsukia. But I have not been handed over the charge till date, and therefore I could not discharge my duty as a lecturer diet Dibrugarh Sabua district so and so. the elementary officer coordinator by a letter dated so-and-so forwarded my original application leave from 1/7/2006 to 31/6/2009. That's the first period, my lord. And also informed that I have joined my duties on 13/8/2013. I'm reading page 93, my lord, para 7.
Yes.
And accordingly requested the director, SCRT Assam, for taking necessary action in the matter. The next paragraph, my lord, that sir, and I'm enclosing here with all my leave application for a period of 1/5/2005 till 31/6/2006, subsequent period of 1/7/2006 to 31/6/2009 for your kind approval. So this is the period where the applications were filed. I humbly submit that because I could not submit my leave application from 2001/7 to 2009 to 12/8/2013 because of the reasons as stated above, I therefore humbly request you to grant my leave of that said period from 1/7/2009 to 13 and also do the needful for handing over the charge in the interest of justice. In the view of the above, I humbly request you to kindly grant my leave for this period of 9 to 13 and do the needful for handing over the charge in the interest, my lord. So the period in which I went back and joined was in 2013, 13th of August 2013, after being declared fit, my lord. This representation was forwarded at page number 94, my lord, in where they have specifically said on the next page, my lord, the paragraph, my lord. In this connection, I'd like to inform that Mrs. Das applied for earned leaves on medical ground from 2006 to 2009, which was already sent to the Commissioner Secretary Assam Department and for sanctioning of the leave by order dated so-and-so. On the other hand, Mrs. So-and-so Diet Shabua is now attached and submitted her joining report on 13th of August 2013. That's the day of the representation, my lord. Therefore, the joining report of so-and-so is enclosed herewith for your kind information and necessary action, my lord. This was forwarded to the Commissioner Secretary, my lord, in the next page 95. Therefore, my lord, it says with reference to the sum, I have the honor to forward herewith 11 numbers of applications along with the relevant papers and joining report of so-and-so, Tinsukia, retained as lecturer so-and-so, which is duly forwarded to the DEO and the Mission Secretary SSA, Tinsukia, for praying on leave on medical ground from 1/5/2005 to 12/8/2013, my lord. So this is the period they ultimately calculate, saying that from 2005 to 2013, I was not available. Whereas from 2005 to 9, my lord, I have submitted my applications and allowing her to join. In this regard is to be mentioned that the lecturer was released from so-and-so as a coordinator. The government may therefore please be pleased to consider the prayer of Das and for her leave and allow her to join in the same post. This, my lord, was subsequently converted into that order, which is at page 98, my lord, passed by the director SCRT. The relevant portion is at page 99. Considering all my leaves, my lord, at page 7, paragraph 7, my lord, whereas the same representation of Ms. Das was confessed that she could not submit the leave application from so-and-so to so-and-so, requested the government to grant leave of the period. Whereas it is noted that during all the period of her post was retained by her name in the government till 2012 to 2013. My lord, my representation was 13th of August 2013 when I went back to join. Therefore, the government may kindly examine and peruse the case of Srimati Das and please to take necessary action for allowing her to join, my lord, as a lecturer of Dibrugarh by granting her leaves available to her. Now, subsequently, my lord, this was not considered. I filed a writ petition in the High Court, my lord. The representation was supposed to be considered, did not consider. I then filed a contempt, my lord. That subsequently now has been considered after 2 years and culminated into the order, my lord. The impugn order is at page, the typed copy is at 119, my lord, which is 8th of August 2023. The typed copy is annexure 17, my lord, is 8/8/2003. And the relevant part, my lord, is at page 121. The last paragraph, my lord. On examination and perusal of the report received from the then director so-and-so, dated 9/9/2014, Miss Das, Srimati Das has availed various leaves, neither sanctioned nor accepted, my lord. So from 2005 till 2013 has been calculated as 10 years of no leaves been obtained at all. Whereas my application from
Anyway,
2005
from 2009 to 13, you did not apply. That's for
Absolutely.
sure.
I admit in
So,
that representation.
Issues only with regard to 2005 to
5 to
2000.
2009. But unfortunately, here in the decision that has been made at page 122, my lord, they say that the entire period cannot be calculated. You have taken leave from 2005 to 2013. So that has to be first considered, because some leaves I'm entitled, my lord. And subsequently, they didn't even terminate me because of this. There was no DP call, nothing. They didn't terminate me. I ultimately retired, my lord, in May 2025, in course of the matter being pending before this court. And they said that in terms of 18, since I have been in leave continuously for a period of 5 years, I don't get that benefit, and the entire period is to be considered as a leave. That is what has not been considered, my lord, with all due respect. Whereas they said that I was allowed to go back and join. That also was never considered.
You were allowed to go back and?
I in 2013, my lord, in terms of my representation, there's an order passed by the SCRT saying that you can allow her to join.
You had asked to join in 2013.
Yes, my lord.
When did you file the writ petition?
My lord, the first writ petition, my lord, is 2019, my lord. That order is
Why did it take you 6 years to file a writ petition?
My lord, I kept writing to them.
Writing
It was a process.
after
It
it
was a process, my lord, it didn't happen.
doesn't extend the period of limitation at that.
My lord, in 2019, I did file the writ petition, and an order was passed, my lord, protecting my right, saying that representation should be considered, but that was never taken into consideration. Also,
That is neither here nor there.
But my lord, I was at least entitled to know. They didn't even take any decision in regards to that. I was kept hanging.
So what do you want? What is your prayer now?
My prayer is, my lord, that they should consider that period from 2005 to 9 at least, and say what I was entitled. And because of the government's action of not even saying that whether I was entitled to join, they didn't even consider my representation then and now also, my lord. They never allowed me to join back and resume my services also. That also was never intimated to me. No actions was also taken subsequently, my lord. And I could not go and join anywhere else because my job was available till May, my lord. I retired only in 3rd of May, my lord. I made all persistent actions to possible to take care of that. Nothing was heeded to.
Yes.
My lord, on behalf of respondent 2, the counter affidavit has been filed. Now, if your lordship comes to page 108, the
Yes.
my lord, I am reading. Yes, 108, my lord. I'm reading from para 8, my lord. This is the stand of the department, my lord, in respect of the impugned action.
108.
108.
There is no para 8.
It's
Page
actually
one?
after 5, my lord. Para 5, it comes straight to 8. 108 page number, internal 3, my lord, of the affidavit.
Internal 3 of the
108 is annexure 14.
Sorry, my lord, here the pagination, my lord, might have been wrong.
So am I supposed to follow your pagination?
I'm sorry, my lord. In fact, if your lordship comes to the affidavit filed on 12th of February 25 by the respondent number 2, my lord.
Okay.
Yes.
That
My lord,
is at
internal page 3, my lord. Paragraph 8.
Page 140.
Sorry, my lord, 140.
Para 8, yes.
My lord, I'm reading para 8. The answering respondent respectfully states that a hearing was held on 17/4/23 at 3 p.m. in the office of Chamber of the Secretary to the Government of Assam to discuss the matter concerning the petitioner in compliance with the direction issued in WPC 650/19. The hearing was attended by the Director of SCRT Assam as well as the petitioner. During the hearing, the petitioner was unable to produce any leave sanction letter, either received by competent authority or accepted by any approving authority. The leave applications were thoroughly examined and it was found that the leave petitions had neither been received nor accepted. Para 9. That upon examination and review of the report received from the then Director SCRT Assam through letter number so-and-so dated 9/9/14, it was found that the petitioner had applied various leaves that were neither sanctioned nor accepted as detailed below. So it was found, my lord, total 14 years, 18 years, my lord. Then para 8, my lord, para 10. That the answering respondent humbly begs to state that as per concurrence of Finance Department number so and so dated 31/2/23, and as per view of Judicial Department endorsed on 3/3/23 and Personal Department on 29/5/23, the government in the Department of School Education, being the administrative department, has decided in compliance of the order of this honorable court to reject the prayer of the petitioner for granting any leave and to regret to allow the petitioner to join as lecturer of CMD branch of DIET, White Speaking Order 8/8/23. Be it stated herein that the said decision was taken by consulting various departments like Finance Department, Judicial Department, Personal Department, and after proper examination of record. Para 11. That the answering deponent humbly begs to state that admittedly the petitioner was found absent from duty without any leave for more than 18 years. Although the petitioner is trying to project that she had applied for leave, however, such leave applications of the petitioner were neither received nor granted by the competent authority. As such, the petitioner was unauthorizedly absent from her duty for a period of more than 18 years. In this regard, the answering respondent humbly begs to state that as per FR 18, normally no government shall be granted leave of any kind for a continuous period exceeding 5 years.
Let us see FR 18.
Yes, madam. এখন দি দিয়কচোন FR 18 টো।
Now, have you followed the rule?
Yes, that is there. But my lord, in fact, the impugn order, I have checked, my lord. In fact, the impugn order says that, my lord, she cannot be allowed to join.
That's okay.
Yes, perhaps for removal.
You see, one thing is that now this is an issue of fact.
Well,
Whether she has submitted application.
correct.
Okay. There's a lot of delay also that is there. But as far as I am aware, subject to what you are saying, whenever there is a question of leave not being sanctioned, regularized or whatever, or unauthorized leave or some decision has not been taken, then either you regularize the leave or you take action
No, correct.
by way of a DP.
That I agree with.
So you have got to take either of the two decisions.
Yes.
Otherwise, you cannot leave the government in limbo.
Correct.
That is government servant. You have to take a decision, either you want to regularize or say that no leave was submitted, and as such, we are going to take punitive action against you for removal in terms of this route for termination or whatever. That you can do. So we can dispose of the petition
Man.
by allowing you to follow the provisions of the rules, 1964 rule, or you regularize. That's your decision.
Yes, correct.
Yeah, and then the question of whether he is entitled to any benefit
Man.
will depend upon subject to the decision to be made in the rule.
Correct. That is the only way out.
That is the only way out.
Yes.
No other rule. There.
Yes, yes.
Yes, Mr. Counsel.
My lord, I have absolutely no problem. That was in fact the first thing I said, my lord, because it specifically said shall be removed from service after following the procedure.
Correct,
So,
correct.
2013, with all due respect.
So
to
the
my-
thing is that since nothing has been done till now,
Rightly so, my lord.
and so we will give them the handle to do it.
Right, my lord.
Let them do it as per the law, and then whether you are entitled to any benefit,
Right, my lord.
it will be subject to the outcome of the departmental proceeding.
Correct.
Okay.
That'll be great. Yes, my lord.
Okay, right. Heard. This is item
Item 7, man.
7, my lord.
7. Heard Mr. R.B. Phukat,
R.B. Phukan. for the
learned
petition.
counsel for the petition. Also heard Mr. Talukdar,
SK Talukdar.
S.K. Talukdar, learned counsel for
My lord, there's elementary education, standing counsel,
Elementary
elementary.
Education Department. Who else?
H. Barwa,
For
respondents 6, 7, and 4.
6, 7, and
4, 6, and 7.
4, 6, and 7. Mr. Datta, you're there?
Second question.
Why?
I'm waiting for item 4 9.
Oh.
He's on the queue, my lord.
Isn't it? Okay, okay. Right. The petitioner's grievance is that. No, don't say that. Wait. The petitioner's case is that the impugned order dated 8/8/2023 passed by the Secretary to the Government of Assam, Department of Education, regretting the proposal of the petition, no, regretting the grant of leave to the petitioner and to allow her to join the post of lecturer at CMDE branch of Diet should be set aside. The petitioner's case is that the petitioner had joined the post of what? Lecturer, Diet.
Lecturer, right, yes.
On.
My lord, I joined on 89 and regularized in 1994, my lord. 17/6/1994, my lord.
17/6/1994. No.
Regularized, yes, my lord.
Wait. On 1/9/1989. 1/9/1980. Full stop. Thereafter, the service of the petitioner was regularized by order dated 17/6/1990.
Yes, ma'am.
Full stop. Full stop. By a notification dated 18/12/2002, issued by the Commissioner Secretary Education Department, the services of the petitioner was transferred and attached with the District Resource Center, Tinsukia, under the Sarva Siksha Abhijan as lecturer Diet. And accordingly, the petitioner joined the District Resource Center, Tinsukia, on 27/1/2003. The petitioner was thereafter allowed to work as coordinator, District Resource Center, Tinsukia, by order dated 8/4/2003, which the petitioner joined on 21/4/2003. Next paragraph. The petitioner's case is that the petitioner thereafter applied for leave from 1/5/2005 till the year 2009 by submitting various leave applications. However, no decision was taken on the petitioner's leave application on submitted on medical grounds by the respondent. The petitioner thereafter continued taking leave for the period from 2009 to 2013 without submitting any applications for leave for the said period. The petitioner tried to join her in the year 2013, which was, however, not allowed by the respondent. Being aggrieved by the respondents not allowing the petitioner to rejoin her post, The petitioner filed WPC 650 of 2019. Before this call. Praying that.
My lord, page 105 and 106.
Just a minute, saying that a direction should be issued to the secretary, to the commissioner secretary to the government of Assam, Education Elementary Department, to take a decision on the petitioner's representation for grant of leave for the period from 2005 to 2009. First up. The next para. This court disposed of WPC 650 of 2019, while order dated 5/8/2019, by directing the respondent authorities, more particularly the Commissioner Secretary to the Government of Assam, Education Elementary Department, to pass appropriate orders by considering the representation submitted by the petitioner. First up. Consequent to the above order dated 5/8/2019, passed in WPC 650 2019, the impugned order dated 8/8/2023 has been issued by the Secretary to the Government of Assam, Department of School Education, regretting the petitioner's application for leave or to allow her to join her post as lecturer at CMDE branch of Diet. Next. The learned counsel for the petitioner submits that unless her leave period, that unless the petitioner's leave period is regularized or she is terminated from service or a departmental proceeding is initiated against the petitioner for non-regularization of her leave period, the petitioner would be kept at limbo without any determination being made with regard to whether she would be entitled to any service benefit. On the other hand, next para. On the other hand, the respondents' counsel submits. The counsels for the respondents submit that in terms of the documents with the director of, in terms of the records with the director of SCRT, Assam, various leave that had been alleged to have been submitted by the petitioner had not been received by the respondents, correct?
Correct.
Had not been received by the
Neither received nor sanctioned.
as such, there was no question of sanctioning any leave application, which were not submitted, which were not received by the state government. Next paragraph. They the Mr. R. Talukdar, Learned Council, SK Talukdar, Learned Council for the Elementary Education Department submits that the submits that submits that in terms of FR 18 of FR 18, comma, no government servant shall be granted leave of any kind for a continuous period exceeding 5 years. As the petitioner was absent from duty since 2002 continuously for more than 5 years, the petitioner was not entitled for any kind of leave under FR 18. He submits that though the petitioner is trying to project that she had applied for leave, no such leave application had been received by the respondent nor granted by the competent authority. I have heard the learned counsels for the party. It is settled law that unless leave is regularized, the state respondents would have to act upon the alleged unauthorized leave that had not been regularized. Further, that judgment I can provide. You all want the judgment?
I'm sorry,
Look for it. There is a judgment that if there's regularization of that, there are only two options available. Either you regularize or you take action against that. Later. Next. In FR 18, which is applicable to the state of Assam, states as follows. I take this. Next paragraph. It is quite apparent that the state respondents have not taken any action in terms of the Assam Service Discipline and Appeal Rules 1964, pursuant to FR 18, and the fact that they have taken a stand that no leave application having been submitted, there was no question of regularization of the said leave period, the respondents would have to act upon, would have to act in accordance with the 1964 rule. Next paragraph. In view of the reasons stated above, this court is of the view that the respondents should take either of the two stands, either to regularize the leave of the petitioner or to act upon the alleged unauthorized absent period by way of the 1964 rule. The respondents are accordingly directed to take action in terms of either of the two options available within a period of
6 months.
to initiate action on either of the two options available within a period of 6 weeks from today. You initiate the action. You can
Initiate, correct.
pay period 6 weeks from today. The question of entitlement of the petitioner with regard to any service benefits that might or might not follow would depend upon the decision and action initiated and concluded by the state respondent. The writ petition is accordingly disposed of. Yes. Mr. Phogat.
May I just request, my lord, if it is not inconvenience, if the respondent authorities decide they can call for a personal hearing if required, I can go and assist in whatever documents is available with me, because they have taken a stand by saying that the applications are not even available, whereas those applications were sent to them. At least a hearing can be given, opportunity could be given.
That we will leave it to them. We'll leave it to them. They take that. They let them take a decision. Either they want to regularize, or they want to start a DP against you. That they have to take a decide. We are not going to restrict them. So let them. They will start they initiate their action within 6 months, 6 weeks.
6 weeks. Extremely grateful, man, for your lordship's consideration. Extremely grateful.
I think let's say the non-payment of area salary.
Yes. Who's appearing?
It's admitted losses.
Admitted amount. Where's the admission?
Losses.
Where is the admission?
The proposal sent, let's say, page 25. This 25, 26.
Yes. What is to be done?
Disposal.
Come to page 33. Annexure 6.
Okay.
Hello, in this case, no affidavit is filed, can be.
What's the question of affidavit? It's a question of salary, is not a question of
Hello, in fact, I don't have any instruction, so it will be difficult on my part to concede anything, my lord. On the basis of the materials on record, my lord, if your lordship disposes, I have done.
Yes, we'll say that this amount should be paid within a certain period.
Because even I don't know, my lord, whether this document is authentic or not. But this document has been, my lord.
You verify this document.
Yes, correct.
And you pay if it's correct. That's
Yes.
all.
So, my lord, next week your lordship may fix.
No, we direct here. Why fix?
Lordship can.
How much time do you want to verify this document?
Yes, correct. That
is
after
the thing.
examination, after verification, yes.
Yes. You verify this document.
Yes.
And you pay.
Yes.
You
4
see?
weeks, my lord, 4 weeks. That
Right.
can be done, my lord.
Heard Mr.
L. Gogoi.
L. Gogoi, Learned Counsel for the petitioner. And Mr. S.K. Talukdar, Learned Counsel for the for?
For my lord, I'm just checking, my lord. My lord, 1, 3, 4 and 5, my lord.
1, 3, 4 and 5.
Yes.
Miss
RM Borra, your lordship.
For finance.
Correspondent 2.
5. That's all. Okay, right. The matter, but the claim for payment of arrears salary amounting to rupees 18,76,059 payable to the petitioner for which period?
1/7/2015 to
For the period from 1/7/2015 to 28/2/22.
plus
28/2/20. The petitioner's counsel submits that the petitioner is an assistant teacher. Correct?
Assistant.
Huh?
Assistant, sir.
Assistant teacher in Narayanpur Boys MV School, Narayanpur, Lakhimpur, Assam. And that he was made an accused in a case registered before under Kopur Police Station case number 138 of 2015 under section 302/34 IP. Yes, what? What happened?
No, my lord, this is the finance.
Yes.
If she wants to say anything.
You want to say anything?
Your lordship, regarding area salary, we only want, if we receive the proposal, we will sanction the amount, but
Correct.
only the parent department have their own budget, your lordship.
Correct.
Only if we receive, we'll do, and I don't know if any proposal has been sent, we have not received anything, your lordship.
Correct. So
That's all, your lordship.
we'll record this case. I mean. The petitioner was, however, acquitted from the charge framed against him under section 302/34 IPC by judgment and order dated 31/3/22 passed by the learned additional session judge, FTC, Biswanath Charyali in sessions number 150 of 2017. The petitioner was reinstated into her original post with immediate effect, directing that her period of suspension would be treated as on duty for all purposes. Void order under memo number DEEO/L/01/complaint/2154-59 dated 26/8/22. The petitioner had received 75% of her salary during her suspension period with effect from 1/7/2015 to 8/2/2020. However, 25% of her area salary amounting to rupees 18,76,059 for the said period.
The corrected amount is 18,96,378.
18,18,96,059.
378.
378. 18,96,378
Plus.
has not been paid to the petitioner.
Plus.
Full stop. Next para. The petitioner's counsel submits that the BEO Narayanpur Block Lakhimpur has sent the arrear salary proposal of the petitioner to the district elementary education officer, Lakhimpur, not Lakhimpur, while letter number BEO/NPR/43/2024/306 dated 5/8/24, page 33, 5/8/24, for payment of 18,96,378. Is, however, the same has not been paid till then. Mr. S.K. Taluga, learned counsel for the Elementary Education Department, submits that the arrear salary payable to the petitioner, as made out in the BEO letter dated 5/8/2024 would have to be verified. And only after the same is found to be correct, can the arrear salary of the petitioner be paid.
In accordance with law.
That should be, I'm not going to say in accordance with the outlaw or something like that. What? Has to be in with the law.
No, Malad, there are certain limitations also Malad, regarding area salary. There are judgments you have to be aware.
No. This is clear. This is he.
That is why I'm saying.
He got reinstated in 2022. So it is within the 3 years period. This writ petition is of 23.
23.
Nothing like that. It is all within law. Next, Ms. M. Burman, the learned counsel for the finance department. R.M. Barwa, sorry. R.M. Barwa. I haven't seen her for a long time, that's why I forgot. R.M. Barwa, learned counsel for the finance department, submits that the issue of payment of the area salary would depend upon the stand taken by the concerned department concerned. Concerned department, by the concerned department. Full stop. I have heard the learned counsel for the part. Now, as can be seen from the letter dated 5/8/2024 issued by the BEO Narayanpur Lakhimpur, the area salary payable to the petition is 1896,378. The said area salary proposal has been sent to the district elementary education officer, Lakhimpur, North Lakhimpur, on 5/8/24. The respondent number respondent number. The respondents number 1 to 4. The respondents are accordingly directed to make a verification of the letter number BEO/NPR/43/2024/306 dated 5/8/2024 issued by the BEO Narayanpur Lakhimpur, page 33. And if the same is found to be correct, the payment for the said amount or rupees 1896,378 should be paid. The entire exercise should be concluded within a period of
3 months for it.
3 months from the date of receipt of a certified copy of this one. Writ petitions accordingly disposed.
Yeah, please, your lordship. Kindly pass over the matter for the time being. She's still in another court.
Your rejoinder was also supposed to be filed by them.
Okay, you have to file rejoinder.
Yes, your lordship.
Last chance. Miss
N.O. Komal. On behalf of KDV.
You write your name. How do you spell?
N.O. Komal.
N-O
Pomong. P-O-M-O-N-G.
P-O-M-O-N-G. Okay. N-O Pomong.
Yes.
Learned counsel appearing on behalf of
KDV.
K. Devi, counsel for the petitioner is granted. How much time?
3 weeks.
3 weeks time to file affidavit in reply. List the matter after 3 weeks. Yes.
My lord, in this case, my lord,
Covered matter.
my lord, in this case, our name does not reflect in the cause list, my lord.
Doesn't
That's why
matter. The issue is this. The issue is that you want promotion or absorption or regularization. The rules provide that it is to be filled up by direct recruitment.
regular principle, yes.
And there is a decision of our coordinate bench in 2024, which is attain finality as on date.
My lord, no, my lord, with all respect, my lord, this case is slightly different, my
Tell
lord,
me,
from
tell me,
the,
yes, tell me, what is
from
the
the
difference?
issue, from the issue that has been passed in the.
No, let us see your prayer. Let us see your prayer.
My
There is
lord,
no difference.
I have been newly engaged in.
No,
this
no, no,
case,
Mr. Counsel.
My lord,
Exposing it off. Your prayer here
my lord,
is
your
to,
lordship,
is
that's
to
what I
by
am.
way of regularization absorption.
My lord, that's what I am submitting, my lord. Here, my lord, in this case, my lord, certain amendment is required in the pleadings, my lord.
No, no,
With all
you,
respect, my lord,
you want, you can withdraw with liberty to file afresh. Otherwise, I'm dismissing your petition. There's no case.
my lord, I'll satisfy your lordship. My lord, there is a judgment of the apex
Counsel,
court.
first of all,
My lord,
it has been listed today on your prayer. It is by order. This
Correct.
is by order.
correct, my
So
lord.
you please,
Correct.
please argue.
Correct, my lord. But while doing the homework, my lord, we, my lord, find it proper to amend the pleadings, my lord.
No, no,
Uh,
no, no.
and accordingly, my lord, we
The-
pay,
We do not, I do not find
my
any
lord,
ground.
a
No,
week time, my lord, for
No, no.
amendment of pleading,
no. No.
and thereafter your lordship, my lord, and the,
If you amend,
my lord.
is it your case that this is not a case for regularization or absorption? Is it your case? Or is it a case for direct recruitment? What is your case?
My lord, those who are eligible, my lord,
How are you going to change?
my lord,
You see,
those,
the issue is again this. The rules require the post to be filled up by direct recruitment.
correct,
You are asking
correct.
for regularization and
No, my lord.
absorption. Now, straight away, that is against the.
That is what the, my lord, mistake that has been, my lord, made. in the
So what is your prayer going to
now,
be here?
now, my lord,
Your prayer is going to be what?
my lord, our prayer would be, my lord, those who are eligible
Huh?
for appointment to the post of regular appointment, my lord,
Huh?
their case shall be considered,
Huh?
my lord, and my lord, if those, my lord, do not have the, my lord, the requisite qualification
Yes.
as per the rules, my lord,
Yes.
and UGC norms, my
Huh?
lord, then some sort of relaxations, my lord,
There is no question of relax.
and my lord,
Do you know the law regarding the relaxation of recruitment rules? What is the law? Tell me.
my lord, because your lordship kindly consider, my lord, these
No,
people,
you see, Mr. Counsel,
these
it's very,
people, my lord,
that is why-
work for
you see-
a multiple years, my lord, for about 15 years, 20 years, my lord, with a legitimate expectation, my lord.
Counsel, this is not a fish market where you overshout the other. You see, the law is clear. Whatever submission you're going to make, it has to be supported by law. Now, first of all, your writ petition suffers from one problem. It has got two classes of persons. One asking for relaxation of the recruitment rules and one asking for regularization / absorption. Now, first of all, for that you need two writ petitions. They're not similar. It's then the writ petitions are not similar. So on that case ground itself, this writ petition will have to be dismissed. You can file two separate writ petitions. Now, the other ground is that you are asking for regularization and absorption into that post of principal or headmaster, whatever. Now, for that, the rules say it can only be done by direct recruitment, not by absorption, not by regularization. And you have not made a challenge to the rules. What remains? Nothing. So the only thing I can tell you right now is, if you want, you can withdraw with liberty to file afresh and file two separate writ petitions, or I dismiss it on the grounds I have just, and this is supported by the judgment of a coordinate bench, which has disposed of a similar case on 11/7/2024.
Well, let us go through it, my lord. Let the matter come up.
No,
My lord,
sorry.
let the matter come up on Tuesday next, my lord.
No,
Your
it
lordship
is-
may dispose it of. Let us
Mr. Counsel, there is a notification passed by this High Court
my lord.
saying that when you want to ask for adjournment, you need to ask one day earlier. We go home every day reading files for tomorrow. You have wasted my time and this was,
Lost
by
it.
order. It was by order. It has been listed today.
Kindly consider, my lord, my name does not figure in the cause list, my lord.
Okay, list the matter. Okay, on your prayer tomorrow. We'll list it tomorrow. You come tomorrow.
Tuesday next.
No, not tomorrow.
Tuesday next, my lord. So that we can go through.
Heard Mr. B.K. Sen, learned counsel for the petitioner. Mr.
Estas, my lord. Higher education.
Learned counsel for
Higher education department.
Higher Education Department. Heard Mr.
ZR Majumdar on appearing on behalf of Dr. P. Agarwal for respondent 3.
S.R. Majumdar.
ZR Majumdar.
Appearing for
P. Agarwal, Dr. P. Agarwal for respondent number 3.
respondent number 3. And Miss name. RCR appear for respondent number 4. Dismissed. I'll pass the order later.
My name should be.
My lord, tomorrow, my lord, tomorrow, my lord. Tomorrow, my lord. Your lordship kindly consider, my lord. Tomorrow I'll satisfy your lordship.
Huh?
Tomorrow, my lord.
I don't know.
My
My lord,
lord, I'm sorry.
Let's just go to division bench.
My lord,
tomorrow,
for all the
Huh?
for all the petitioners.
Mr. A. Paul appears for all the petitions.
All the petition.
Mr. B.K. Sen and Mr. A. Paul appears for all the petitions. You're not taking a hint. Yes. Dispose of, dismiss.
my lord, I'm thinking twice, my lord. Shall we withdraw with liberty, my lord? Because if it is dismissed, my lord, I'll be nowhere, my lord.
You can go to division bench. You can try your luck.
Again, there will be a hassle, my lord. Your lordship, instead of, my lord, we shall file a writ petition, my lord, with liberty, my lord. With liberty.
You have to file.
Because there
two writ petitions. You cannot file one.
there are some error in.
Okay, right. Heard Mr. B.K. Sen and Mr. A.B. Paul. A. Paul for all the writ writ petitioners. They submit that they may be allowed to withdraw the writ petition with liberty to file a fresh.
If so advised.
If so advised. Their censor appear for the part that way. Okay, already the thing. Now on the prayer, the petitions council. This the writ petition is dismissed as withdrawn with liberty of last time.
Obliged.
Yes, my lord. Obliged.
Yes.
Lordship.
Better? Okay, tell me. Tell me, what is
Yes.
that case?
Well, the petitioner at first was appointed as statistical.
Where is that, where is the impugn order page?
Impugn order, page 54.
Your Liaquat Ali.
Yes.
So what is your case? Your case was that you were promoted to UDA,
Yes,
but you were reverted back.
reverted back.
But then your pay did not change. Your pay as UDA continued.
Duty as UDA continued.
You should have retired as LDA, but you retired
I
as
have
UDA.
retired as LDA, but all along till the day of my
You are paid,
retirement,
you are paid.
my service was taken as UDA. Now, Honorable Supreme Court says, my lord, that if there is no any fraud committed by the petitioner and he has discharged the work and it is due to the departmental authority's mistake, he has got this benefits and the report was called from the principal, my lord. The principal's report, lordship may kindly see page 55.
Yes.
In page 55, lordship would see here he has given details of my salaries from first I was a laboratory assistant.
You see, you are a intelligent man. You should be knowing that once you are a LDA, your salary should have been lower. You cannot get the same salary as you did.
No, my thing is this, all along my duty was taken as UDA and the headmaster, principal has also certified that he was working.
So you are supposed to give back how much money?
Some amount.
How much money are you supposed to give back?
That is one aspect of the case. Another aspect of the case is that, my lord, I should be paid the pensionary benefit like an UDA.
No. You have to be paid pensionary benefit as per the post you retired in.
Yes,
You
but my
cannot,
lord,
you cannot give UDA. There's no,
my lord, I have given some citations.
there's no case there. But only one thing we can consider is that you also were not careful. You have paid him the pay of UDA. So he should have been given LDA. Of course, both sides are guilty. But he is also guilty because he has kept quiet about it.
No, I am in the same school, my lord.
No, whatever. But you see, no. Supposing a person is appointed as a court master. He gets promoted as a court master. But actually he should have been in the 4th grade. So he gets demoted back to 4th grade. He still gets paid as a court master while being a 4th grade employee. Then he will immediately come to know, oh, I've been getting more pay than I should. It's normal. Let us not try to.
Our High Court has
not insult each other's intelligence.
Yes, my lord. Our High Court has also upheld this by coordinate bench of our High Court has also followed the order of the Honorable Supreme Court.
Maybe. But then that's a different thing. Those where now here LDA is a grade 4 post.
No, LDA is a grade 3 post.
Grade 3. UDA?
UDA is a grade 3.
Grade 3.
And
LDA is UDA is superior to LDA.
Huh?
UDA is superior to
No, I know.
In this case, school office, all bill are prepared by the UDA and LDA.
Oh.
He was functioning.
He's the main person.
This is the thing.
No.
So
That Rafiq Masih is the distinguishing in that, only that count only.
Okay.
No. Principal's letter is self-explanatory in nature. He has said everything. Even after my retirement, he submitted.
Pay is made by you.
No, that is.
Salary slip is made by you.
No, it is the drawing and disbursing.
Bill is made by you.
Drawing and disbursing authority is the principal. Now, Lordship, our High Court has upheld that. Honorable Supreme Court has been followed by our High Court. That 2015 for GLT 32. Para is not there. But if para is counted, I am reading, my lord, this. However, I am reading the last part of the order. However, in the recent decision in Rafiq Masih and other supra, the apex courts surveyed the law relating to recovery of excess salary done by an employee, including the two cases cited above by the apex court in Chandi Prasad Unial and others supra, after referring to the various case laws on the subject starting from Shyam Babu Verma so, the apex court held that it may not be possible to postulate all possible situations of hardship which should govern the employees on the issue of recovery, where payments have mistakenly been made by the employer in excess of the entitlements of the employees. However, based on various case laws, certain situations where recoveries by the employer would not be permissible in law and have been called out. The instructor said it is not possible to postulate all the situations of hardship which should govern employees on issue of recovery where payments have mistakenly been made by
No,
the
it's-
employer
It's okay.
in excesses. So,
Representation of fraud.
no, my learned friend said that I have prepared the bill. No, EDA is there.
Huh?
EDA is there. But EDA, no. It is some Begum who is there. She was the UDA. And when I was promoted as UDA, then on her prayer, I was reverted back. And she was the UDA. So UDA is the main responsible person to prepare the bill and it is to be submitted to the principal. Now, I am not either the preparer, I prepared the bill, nor
Counsel, you are an intelligent person. You will know that if you are on a higher post, you'll get a higher pay. If you are on a lower post, you'll get a lower pay. Let us be fair. Now, I'm trying to look out for both your interests. Why don't you settle for 50%?
but they have taken my service, sir. That is why I would kindly
Huh?
consider. They have taken my service and as an UDA. And my last pay was 50,000.
Sorry, that cannot. They have taken your service as Prime Minister also, or Home Minister also, or a Judge of the High Court also, doesn't matter. However, they've taken your post. The issue is you can only get the pay that you're entitled to. You can only get the pay that you're entitled to. Just because they made you work as something which you should not have worked, or that does not give you any right.
Supreme Court has very clearly stated all these matters, which citations I have given, that the person has not committed any fraud. Because it is the principle.
No, Mr. Counsel, by keeping silent, you also commit a fraud. It is your duty. You see, yesterday there was Constitution Day. There's just one thing I said, a very small thing. Constitution has given us fundamental rights. Certain rights given. But we also have
some duties. Fundamental duties are
to follow. So your fundamental duty, forget about 51A, Article 51A. Your fundamental duty is to tell the truth. It is to tell the truth. Supposing today you are a UDA, and then tomorrow you are a LDA. Immediately, if you still get the pay of UDA, you will know this is not the pay of the LDA. But similarly, if you are a LDA today, and in next month you are promoted to UDA, if you are given the pay scale of LDA, immediately you will go and shout.
Yes.
The
same is
Sarna outside the office.
Same higher secondary school, is working, Begum is working, I am working, same, only hardly there are 25 teachers or staffs. So need not to inform, everybody knows, every time it is discussed. Even then my service was taken as UDA. So my prayer is this, what was my last basic pay? That should be given.
Last basic pay as you are entitled. You cannot be given something you are not entitled. If you are given something you are not entitled to, that is not as per law. You have to be given which you are entitled to as per law.
As per law means
It has to be as per law.
Because they have taken my service. So that was my grievance is there. In the result, Lordship, it is the finding of the Honorable Apex Court 2009 3 SCC. In the result, the appeals are allowed. In part, the impugned judgments as so far relates to the direction. My Lord, 2009 3 SCC 475. Here are some categories. Para, my Lord, 61. But discussions, it is categorized, several categories have been made. several categories have been met, that regarding the payment of pensionary benefits. Here, para 34 may be seen.
Look, para 57, it is very clear.
Para 57, yes, that may be seen. This court in the Catena of decisions has granted relief against recovery of excess payment of emoluments allowances if the excess amount was not paid on account of any misrepresentation or fraud on the part of the employee. If such excess payment was made by the employer by applying a wrong principle of the employee, if such excess amount was made by the employer by applying a wrong principle for calculating the pay allowance or on the basis of a particular interpretation of rule order which is subsequently found to be erroneous, then
Para 58 also.
yes, the relief against recovery is granted by courts not because of any right in the employees but in equity, exercising judicial discretion to relieve the employees from the hardship that will be caused if recovery is ordered. But if in a given case it is proved that employee had knowledge that the payment received was in excess of what was due or wrongly paid, or in cases where the error is detected or corrected within a short time of wrong payment, the matter being in the realm of judicial decision, courts may, on the facts and circumstances of any particular case, order for recovery of the amount paid in excess, so and so, so and so. Undoubtedly, the excess amount that has been paid to, it is para 59, my lord, paid to the appellant teachers was not because of any misrepresentation or fraud on their part, and the appellants also had no knowledge that the amount that was being paid to them was more than what they were entitled. It would not be out of place to mention here that the finance department had in its counter affidavit admitted that it was a bona fide mistake on their part. The excess payment made was the result of wrong interpretation of rule, and that was applicable to them, for which the appellants cannot be held responsible. Rather, the whole confusion was because of inaction, negligence, and carelessness of official concerned of the government of Bihar. Then, Lordship may kindly see para 61. In the result, the appeals are allowed in part. The impugned judgment, so far it relates to the direction given for recovery of the amount that has been paid in excess to the appellant teachers is set aside, and the part of the impugned judgment whereby it has been held by the division bench that the amended provision of FR 22 would apply to the appellant teachers is upheld. We direct that no recovery of the excess amount that has been paid to the teachers of secondary schools be made irrespective of the fact whether they have moved this code or not. We also direct that the amount that has been recovered from whom some of the teachers after impugned judgment was passed by the High Court, irrespective of the fact whether they have moved this code or not. So, my lord, my submission is this, my lord. Once I was promoted to the post of UDA. I did several years as UDA, my jobs. Then on the basis of one request came some Begum, I was reverted back. But my nature of duties remained as before. So that was my bona fide, yeah. So then the headmaster also prepared.
Then you file a case saying that since I've been working as a UDA, I should be given the pay of a UDA.
I'm a retired man, 3 marriageable daughters.
Okay.
How can I fight with the state?
No case. For the period he worked as UDA, for that period he'll have to be given the salary of UDA.
No,
I think that part has been given.
Recovery part, but that,
Only for the period he was reverted back. Only from then.
Yes.
Only for that period.
Yes.
Correct. Yes.
Lordship, my point is simple, that there is no doubt the law laid out by this Honorable High Court and the Supreme Court regarding recovery. There is no doubt. But here in this case, one peculiarity is that he is claiming that he was referred to LDA, but he was allowed to or asked to do the job of UDA. The same person.
No.
If his person is accepted, then he is the main person of drawing and disbursing all the salary for his own favor, Lordship.
That is
So
the-
he has the full knowledge as distinguished in paragraph 58, Lordship. So that he cannot get rid of by the Rafiq Masih, Lordship. This is my humble submission.
My prayer was twofold, my lord. No access, no recovery, and second part was that as I discharge duties as UDA, so pension should be accordingly paid. These are two my prayers, humble prayers. Now your lordship would decide, because state cannot take any forced labor from me. Now my learned friend is saying, I know.
But then.
I prepared the bill. That is beyond record, my lord. That is beyond record.
You have admitted that you are both doing functioning LDA as UDA.
Yeah.
No,
Admitted.
no. My claim is based on the principal's letter. I am not personally saying. The principal is saying this. 50 page 55 lordship will say everything is there.
You see, one thing is very clear. You were in the knowledge that you were having excess pay. Supreme Court has said that when you are in the knowledge that you are having excess pay, you cannot have the benefit of Rafiq Masih's case.
Fraud is the main thing. That is the motto of the Honorable Supreme Court, as I understand. There is no fraud, because in the same school I am working, principal.
It's not only fraud. It says also, if it is proved that the employee had knowledge that the payment received was in excess of what was due.
No, my bona fide belief was there that I am discharging the duties of UDA. So, but a bona fide belief.
Where is the document showing that you can discharge the work of a UDA?
No, in my statement of the writ petition, I have stated.
Then in that way, this statement also we will take into
No,
account.
his oral statement, but no one of my. In writing, they have not said this.
Yes, Mr. Talukdar, you are here?
Lordship, yes. Lordship, Lordship, I have also filed a affidavit, Lordship, in terms of request from the department, Lordship, whenever pension papers received in the office, Lordship, then we found that some wrong is going on. That is why we returned the pension proposal, Lordship, with a request to recover, Lordship.
How much has been recovered?
Nothing is recovered. Because High Court has passed the
Order.
High Court has passed the order, some relief, providing some relief. Steps to be taken. Some amount of pension.
Lordship, his overpayment was 13,81,130. Page 96 of my affidavit.
Page 96.
13,81,130.
$96? Page 96?
Yes. My affidavit.
Page 96? I don't have page 96.
If it filed by respondent number 3.
Just a minute. Page 96. Yes.
Lordship will find in page 95, Lordship.
Huh?
Serial number 3, recoveries. In the
Yes.
ZPO, Lordship. That F, other government dues, rupees 13,81,130.
Total recovery is 18 lakhs? What is it?
Total recovery, Lordship, 18,15,874. Lordship, because there is a provisional DCRG also, Lordship, 4,34,700.
Also, you have already recovered that.
Yes.
So altogether, you have got to recover 18 lakhs.
18 lakhs.
Quite a bit for this person to give back. Can you agree to 50%? Mr. Data?
I have to take it.
95 nail.
Because that's quite a bit. 18 lakhs quite a bit. So you find out if you can agree to 50%. If 50%, then if the settlement can be made at 50%, then we close the rate petition.
But you can mention and I will take instruction.
Otherwise, no case. You have to, it has to be done.
4 lakhs
You have
34,
to agree.
Lordship, 4 lakhs 34,744 already he received as provisional DCRC, Lordship.
No, that's all right.
But now recovered is 13 lakhs 81,000.
That is what. Now, if you can agree, then he'll have to pay another 4 lakhs only. So that will be better. Otherwise, he has to pay 13 lakhs. That'll be too much. You tell your client also, let him agree. Legally, you are in a bad wicket.
He's entitled to DCRG Lordship 7 lakhs 63,000 and 10 lakhs 52,551 will be recovered from his future relief.
That's what.
Normally, pension matter court should be lenient.
This is out here different. This is different. Right. Heard Mr. M.U. Mahmood, Learned Counsel for the petition. Also heard Mr. P.P. Datta, Learned Counsel for the
Extending council, the 1, 2 and 4 Lordship, extend
one
council application.
four. And
Yes, I am
Mr.
three
R.K. Talukdar for point number 3. The petition has prayed for setting aside the letter dated 7/9/2021 issued by the respondent number 3, comma, for the recovery of the excess drawn salary by the petitioner, comma, since the date of reverting back to the post of LDA from UDA on 25/7/2008 till the date of his retirement, LDA on 31/12/2009. That's para. The petitioner's case is that he was promoted to the post of UDA on
UDA on 5/3/98.
5/3/1998. However, he was reverted back to the post of LDA from UDA
On
25/7/2008, which is that page
page 25.
by order dated 25/7/2008. The petitioner retired on 31/12/2019 as LD. When the proposal for payment of pension was sent to the respondent, it was discovered that the petitioner had been paid his salary from 25/7/2008 on the salary payable to a UDA and not LD. Thus, the respondents have issued the impugned
Page 55.
letter dated 13/3, this page 95, no?
Impugned order 7/9/21.
Page
55.
54 Lordship.
54, yes.
Annexure 7.
impugned letter dated
7/9/21.
is it 7/9/21 for recovery of the excess salary paid to the petitioner. The letter dated 13/3/24 issued by the senior accounts officer, principal accountant general, ANESM, also shows that the total recoveries to be made from the petitioner is 18,15,874. And that rupees 4,34,744 has already been recovered from his provisional
Already
DCRG.
paid to him, Lordship.
Huh?
Already received, Lordship.
Has been paid to him.
Yes,
But then
as provisional DCRG, Lordship. I've stated in my affidavit, Lordship.
it has already been paid to him
Yes.
as as provisional DCRG. Full stop. The other full stop. The petitioner's counsel submits that the pension that is being paid to the petitioner is being paid or not? Pension, no.
No, Lordship, PPO issued, Lordship.
Huh?
Pension payment order, that is Lordship. Annexure 2.
Lump sum
Already
amount
pension
being paid.
payment order issued, Lordship.
Submits that the pension payment order issued to the petitioner
On 13/3/2024.
on 13/3/2024 has been made on the basis of the salary payable to a LDA, though the same should have been made in the salary payable to a UDA. Next paragraph. The petitioner's counsel submits that though the petitioner had been reverted from the post of UDA to LDA on 25/7/2008, he had been made to do the work of a UDA till his retirement. As such, his pension would have to be should be calculated on the basis of the last pay he was given. That is the pay scale of an UDA. Next paragraph. The learned counsels for the respondents, on the other hand, submit that the petitioner was to be given the pay of LDA from 25/7/2008, when he was reverted back from the post of UP. The petitioner was well aware that he had been paid his salary in excess of what was payable to an LD. Further, the appellant was making the salary bills of the school in which he was working.
It is under objection, man.
Anyway, that is their submission. You can object, that's their submission. Even your submission is your submission. Thus the petitioner could not take advantage of his own wrongdoing. Further, when the petitioner retired as an LDA, his salary would have to be considered, his pension would have to be considered in terms of the salary payable to a LDA and not to a UD. I have heard the learned counsels for the part. A perusal of the various judgments of the Supreme Court, some of them being Said Abdul Qadir and others versus State of Bihar and others, 2009, 3 SCC 475, CM Babu Verma versus Union of India, 1994, 2 SCC. 521. Comma. State of Punjab and others versus Rafiq Masi and others. 2015, 4 SCC 334, etc. Would go to show that relief against recovery of excess payment of salary and allowances can be granted if the excess amount was not paid on account of any misrepresentation or fraud on the part of the employee. And if such excess payment was made by the employer by applying a wrong principle for calculating the pay and allowance. Further, recovery of excess payment should not be made against class 3 and 4 grade of employee. However, as can be seen above, however, as held in the case of Said Abdul Qadir Supra, a recovery of excess pay is allowed by the court if it is proved that the employee had knowledge that the payment received was in excess of what was due or wrongly paid. And the employee had knowledge that he was being paid more than what he was entitled to. In the present case, the petitioner would have surely known that he was being paid the pay of a UDA, though he was entitled to the pay of NLD. On the other hand, the respondents also have been lackadaisical in their duties by paying a higher amount to the petitioner than what he was entitled to. Mr. PP Datta submits that he will obtain instructions as to whether a settlement can be made between the between the parties to the tune of recovery of 50% of the dues payable by the petitioner. When? This is the matter.
After 2 weeks.
This is the matter after 2 weeks. That's the best we can do, Mr. Mohammed.
The matter may be relegated to the mediation also.
No, at this stage, it is hard already. The mediation, that had to be done earlier.
Mediation, your officers might not be very.
No, they do not come, my lord. In 4 or 5 cases, we are suffering. The officers do not come or comes.
It's quite a bit. Actually, you all were not careful also. He also, I mean, everyone was not careful. He also was quite cunning. Now he has eaten everything, finished, and retired. So just look at it if possible. It will come before your what bench is that? I don't bench 2 or 2. The bench 2 matter, no?
Yes. Right, bench to pension matter, bench to
Education institution.
So it'll go back to that bench after 2 weeks. Yes.
Why it is listed then? I don't know. Oh, yes.
Today, because I'm taking this up because of the bench is not sitting. So it'll go back to the bench. Otherwise, that's the only thing. Otherwise, very difficult. PP data, you try. See, he's now retired, so no money.